Today we have with us Justice Sanjay Kishan Kaul. After serving 22 years as a judge in high courts and now in the Supreme Court, Justice Kaul has completed his tenure in the Supreme Court this week. Among his several landmark judgments, one of the most important judgments this year was his Article 370 judgment, which was keenly followed by the entire country. Thank you, Justice Kaul, for
Thank
being
you.
with us here at Bar and Bench's interview. So just to start with, three of your classmates at the Campus Law Center, um, including yourself, went on to become Supreme Court judges. Did any of you anticipate or think that this would happen 30 years later?
So, the Chief Justice came from a judicial background. I didn't come from really a background in that sense. I've said sometimes I didn't even think I was going to go into law till I was persuaded by Justice Kirpal to think as an option and went into law. Rishikesh wanted to practice, so we knew that. Justice Bhatt also wanted to practice, but where we will all be is very difficult to imagine in those days. You don't look that far actually in this sense. So, to me, once I joined the bar, this was a option, I would say. To me, it came to a right time. I think I had just become a senior. Had spent a year on after my designation when I was offered very good age at that stage of time. Offered in the right way, persuaded in the right way, so I joined.
So if you could just tell us something about those days at the Campus Law Center.
So, academically, I was particular in attending classes. In fact, all our group, we had a number of people who joined law. Parag Tripathi, Dhananjay, Rishikesh, Ravindra Bhatt. We were all, I think, students who believed in studying and knew that we had not just come there to pass time. And I felt that a regular class helped in absorbing what the teacher was trying to teach.
Right.
And since it was more of an internal system of examination, it helps us understand what is the expectation from us. Except that I was quite active in other things. So I continued my theatre, which was unusual in law. We did not have any theatre society. I chose the plays, I directed the plays, I acted in the plays, I did makeup in the plays, did everything. So it was and a lot of us did it together. So it was a very satisfying experiment because it's something which was my hobby right from school to college and on. I was playing at that time squash. I was fitter. I was the captain of the squash team for the college, law college. And I got involved in the local political setup of the law faculty.
Okay.
Not very successfully. I realized it was not meant for me because it required a different thought process to it.
Right.
And so I kept my day occupied. I mean, I was to stay near the university. So I was not bound by going on the U specials which used to exist that time. Possibly do still. And a lot of my friends were staying in the hostels. So I had the advantage of spending time with them. They had the advantage to be able to come home and have food, which all hostelers want. So it's a fairly active day which I spent, which is a mix of academics, mix of cultural activity, social interactions. Those were not the days when TV and other media and other methods remained.
Right.
So the really social interaction was the time you spent with your classmates and peers. And that's something right through college and law I did. So I very good friends in college from my residence and in law from the hostel people.
Lovely. So, how were your early days at the bar? Like, is there any particular lawyer who had the most impact on you?
So I started working with a law firm, which was Khaitan's, under the tutelage of Mr. Patra, who used to be there. For about over a year I worked. I think the real learning experience was he was extremely precise and to the point. How to pen down an opinion, how to make a draft which doesn't go here and there. So I learned from him in this sense of following a more brief kind of a methodology. I'm a left-hander and I'm a slow writer. So right through college or school education, I knew that if I have to complete a paper, I must do it more briefly, must learn to express my views more briefly. I've never used an extra sheet in my life. And my typical answers, even in law, would not cost normally 4 to 5 pages
So you
maximum
never
for a
needed a
question.
thread.
No, never used a thread. I used to wonder when I used to see people, in the exam center, take pages after pages and write. I of course, had a small handwriting and a left side handwriting, left-hander's handwriting, not a very good handwriting. So that's how I used to take the exams because of that. So that's something I think which helped me later on also. And after a year's time, I was very keen to do active court work.
Right.
So though it was a learning process, I wanted to work with somebody where I would get an opportunity to appear in court. Um, I joined the chambers of Mr. Arun Kumar, later Justice Arun Kumar, became a judge of the High Court and Supreme Court, both. I worked for 4 years with him. It was a great experience to my mind because he gave me a lot of opportunities from day one. He had a very large volume of work, so the junior had to attend cases physically in court. And I was appearing from the very beginning, maybe smaller matters, other matters. And I believe the judges also give that little bit of indulgence when you are comparatively new in the profession.
Right.
That's why I always want the juniors to appear and take those opportunities, keep encouraging them, because I benefited from that opportunities which were there. And after some time, he would tell me that, you tell me where I have to appear, where you are required, and you attend to the remaining. So doing volume work in his chambers, what a great exposure. You learn to handle from a very early age a number of matters in which you are appearing. Right. And that, I think, stood me in very good stead when I went on my own. After that, I started working on my own. The senior always remained a senior to us.
Right.
So if there was a problem, one could go to him, or for that matter, any senior. They were not times of, the 80s were not times when people were possessive about their brief so much. If you felt that you needed some help from any senior you knew in the profession, you could go there and ask him to solve your problem. And they were most cooperative in this sense. So Delhi High Court became my home in that sense. You are working there till whatever 8:39. You go in the morning. So most part of the day is spent in that High Court premises.
So, it was about 22 years for you as a judge, as a judge of the Delhi High Court, Madras High Court, Punjab and Haryana High Court, then the Supreme Court. It's a very straight question, sir. Which court do you hold very close to your heart?
So, Delhi is my parent court. But I have great love and affection for both Punjab for the 14 months I spent. Punjab is a very affectionate place, and both the bar and the bench received me extremely well. Did not have a problem, did not have a strike. The bar used to come and discuss, and they knew, and I had made it clear, if I could do something, I'll do it. If I can't, I'll tell them on their face, this can't be done.
Right.
And that worked well. Being one of the younger judges in Delhi High Court, I was involved with the administrative setup almost from the inception. The senior judges thought that since I have a long tenure, I must be, brought on board, including especially infrastructure work and projects. So at a very, very early part of my tenure, I was became member of the infrastructure committee and other such committees in a longer term perspective. And those people gave me the opportunity to work on it. That's something I followed in Chandigarh also. My movement for Chandigarh was not expected, at least by me at that time. I had been told that I'd be there in Chandigarh for some time because there were already representatives from Delhi and Supreme Court, which was fine by me because when I became Chief Justice, I was 54 and a half in Punjab, Haryana. And the movement occurred suddenly, not very palatably, because I did not expect that for my personal reasons and family reasons. I didn't want to go that far. I had 2 daughters who were yet to be married or settled. But when it came, I went there and took upon the challenge. That was a completely different kind of a challenge.
Right.
I think things had gone wrong in Chennai for a long time. And when I tried to operate in Chennai on the same parameters as Delhi and Punjab, it didn't work. And therefore, I had to be tough at times, deal with scenarios which I never thought could occur. I cannot think of a strike in which a lawyer's procession is going through the corridors or trying to enter the court complex. It was completely alien to me. That too, the first time it occurred was over an issue of Indian seamen being taken into custody in Sri Lanka. So I said, look, this is not my jurisdiction. How can I help you in this? So no, this is a sensitive issue or
Okay.
close to the heart. So therefore, we'll do it. But when they did try to come to my court, I just they opened the door. I remember cautioning them, please don't try this. I would request you to move, otherwise. And the first time they shut the door and left. But it was a little awakening for me that can such a thing happen in a court? And then the whole problem kept on escalating over a period of time because the culture of strike had taken over there. I've been very particular on this. As a lawyer in Delhi, I was treasurer for 2 terms of the bar. I saw 2 of the longest strikes and the futility of all this. So one was a strike which was different in character because it was meant for a judge. Justice T.P.S. Chawla was not been confirmed as the Chief Justice in the court. And the bar went on strike for the first time for a judge, not for something themselves. And we were led by Justice Y.K. Sabharwal, who later on became the Chief Justice of India. Almost 25 days that strike took. Ultimately, negotiations with the government took place and strike was called off and he was confirmed there. The second time it was the episode over Mrs. Kiran Bedi which escalated.
Okay.
And we were younger lawyers. 2.5 months we were without work, not doing anything other than the patronage of my senior executive members who would invite all of us for lunch somewhere or the other to discuss what to do next. So I realized that these are strikes for legal fraternity is like ride of a tiger. You don't know when to get off it.
Right.
The tiger will eat you up. And you are the litigant who comes, how does he keep on waiting for justice? He has come to you to help. We are in a sense a daily wager. And I've never understood how lawyer cannot work. And I really never did or participate in any strike in that sense after that. I wanted to push always to see that the work culture continues, and that's part of my judicial culture also, which I tried to imbibe. So Chennai was one of the most difficult challenges, but no single person makes an impact. I'm credited with a lot of things there, but I think the judges gave me a carte blanche. Please bring some discipline into this court. So unless you carry your peers and colleagues with you, you can't implement difficult decisions. And there was a practicing bar there, which was also unhappy with this environment. So, small things, issues would arise. And Madurai, say example, my first couple of months went on a strike on whether a particular judge should continue in the bail roster or not. I said, this is none of your business. So I could be tough. I told them, look, you after great battle have got Madurai as a court. You don't want to work, I have the concurrence of my full court. I'll declare concurrent jurisdiction, call the judges here, and we'll operate from Chennai. In which case, you will lose the work. It got called off. But there were periodic challenges, discussions went on with the bar. To me also, it was a new place, the culture was different, the working environment was different, the appointment processes were different. And to them, I was somebody who had come for a little far off. And initially, they may have thought that I may not fully understand what they expect. But it was a mutual understanding which grew to a stage where, as a working person, I thought the most satisfying part of my tenure, or the prominent part of my tenure, was Chennai, because I was able to,
You had actually
deal with the situation.
Termed it as a punishment. Was it sort of a punishment posting initially when you received the transfer order?
Well, I didn't call it punishment. I knew Chennai wasn't a problem. I had been informally assured earlier that I'll go to stay in Chandigarh. Suddenly, off the blue, it occurred. I did approach the Chief Justice and the senior judges that, why is this occurring? What they conveyed to me was that we are looking, in their perspective, looking for somebody with a strong hand to go to Chennai. And they zeroed on me at some stage. They claimed reluctantly. I had before that also one of the collegium members had a couple of months ago asked me, are you willing to go there? I said, I've just come here, why send me there? So I've never viewed it as punishment posting, but the disturbance from Punjab, Haryana to Chennai came suddenly. Okay. Maybe I'd gone to Chennai originally, it would not have been so much of an issue. But it was the most satisfying part of my tenure. And for somebody who went reluctantly, fell in love with Chennai, I still believe it's been. Chandigarh, Chennai, Delhi are three homes I have, I feel.
I have to ask you, did you get hold of Tamil?
Not really, but I knew the importance of Tamil language there.
Right.
So when I used to speak, I used to make it a point to be coached in something which I could begin or end in Tamil. It was to connect with the people, because
Right,
the language
right,
is a very
right.
important issue there. I didn't beyond that get time to learn Tamil, because the work and the administrative work really kept me occupied throughout day and night.
So, just taking it forward from here, do you envision Supreme Court of India to be a solely constitutional court? If yes, how does that work?
So it ceased to be really a constitutional court long time back. Anything and everything comes there. Question is, how much should come? That's, I think, a challenge. Now, a lot of people say this is the final court. Yes. But the final court has its own contours. Even sitting in high courts, I would say that if I cite in a jurisdiction, suppose you're sitting in a revision, you're sitting in a writ petition, you're sitting in a suit, the manner of dispensation of justice and the procedure is different. I used to call it the maryada of jurisdiction. Every jurisdiction carries its own maryada, and we must adhere to it. Otherwise, it'll go here and there.
Right.
So, Supreme Court, over a period of time, what has happened is that they have we have entertained everything and anything because it's the last court. Now, how to solve that problem? I strongly believe that we must analyze as to how many tiers of scrutiny will we give to a matter. Say for a revenue matter, the High Court, if you come to the Supreme Court, is the sixth tier of scrutiny. For a tenancy matter, it's the third tier of scrutiny. Now, two independent judicial scrutinies, I believe, are enough, unless it's really a constitutional issue involved, some serious interpretational issue arises. If we start perceiving and correcting what we believe is errors, or which is a different perspective from the High Court, there is a problem. We can't sit as a High Court judge in the Supreme Court. So as to often say, maybe I would take a different view.
That is a very important.
In the High Court, but that's not good enough for me to interfere. So that's the difference in exercising jurisdiction. I believe if we informally in Supreme Court agree to a norm rather than an individual basis, it'll help. Reason is we are not one single court like the U.S. Supreme Court, which operates in a unison in terms of sitting. So every bench is a Supreme Court.
Right.
So you have on a Monday, Friday, 13, 14 benches, and there are bound to be a difference of perception how legal work is to be carried out.
Right.
It's the final court. Some discussion maybe in that scenario would help. So I personally followed a practice, and the lawyers knew that this was a practice. So if in a civil case there was three concurrent findings, I said, I don't touch it. If there is a first appellate court and the second appellate court concurrent finding, I will not touch it. Yes, if two courts concurrent finding is reversed in second appeal, I will certainly look at it very closely. Similarly, tenancy matters. If a routine tenancy matter comes and two forums are concurrently doing so, why should we touch it? The exception to all this was bail, to my mind.
Right.
I initially, when I came here, also thought there was discussion that are we making this into a bail court, which should not. But it's an issue of freedom of people.
Absolutely.
And somewhere jurisprudentially, the bail jurisprudence had taken a different turn from that bail would be the rule.
Right.
So if you see across the Supreme Court and across the benches, I would say, almost 1/3 bail matters, I think, have called for interference, including anticipatory bails.
Right.
Which is a reflection of some sort of a problem where the highest court is required to interfere in bail. Nowhere, I think, in most countries, I would not think of bail being an issue which the highest court has to address. The result of all this is that on Monday, Friday, which is 2 days, go in miscellaneous matters. Notice issued maybe certainly less than 20%. So what is happening is we are spending 2 out of 5 days, which is 40% of our time, really dealing with whether a matter needs to be entertained or not. And on those 2 days, 80% plus faces dismissal.
Right.
So that's a challenge. I don't know, some thought process at some stage will come as to what is the solution. There have been discussions, create another appellate court, a regional appellate court to deal with
Absolutely.
it, benches. I'm not too sure that is a solution, because I believe the solution is how many scrutiny levels do you need? If there was a court above the Supreme Court, also 50% of our orders would get interfered, because it's another tier, another perspective.
Yes.
So I believe, as I said, 2 tiers are sufficient.
So, there has been a recent, I would say criticism or a spate of, opinions coming from all quarters, that the recent perception is that the judiciary on some very important matters have sided with the executive. What is your take on this perception?
So let me put the question to myself. What is siding with the executive? What is the role the court is supposed to perform? A matter comes, it's supposed to adjudicate. Now, the government may succeed, may not succeed. If in a couple of matters the government has succeeded, does it mean that we are supporting the government? I've said so earlier, our job is neither to support nor to oppose the government. It's not our job to play the role of an opposition or criticize the opposition. There is a political domain which must be played outside the court,
Right.
which should not be brought into court. But if there's a legal domain which comes into court, we are duty bound to address it and decide it. One troublesome aspect has been that the perceptions have been so different in the political spectrum that often the Supreme Court is being visited on the same kind of issue or same issue arising again and again, and which is also creating a problem and pressures in terms of time frame which is consumed by these matters.
Right.
And when do you address the normal routine matters?
So, just an example offhand, the Prevention of Money Laundering Act. That was perhaps one of the most anticipated cases which the country was looking at, thinking that if the verdict goes here and there, then there's a clear line that we draw, deciding with the executive or not. And the Vijay Madanlal Chaudhary judgment is standing the test of time as of now. Do you think how can the Supreme Court, if there has been an error committed, can the Supreme Court correct it at any point apart from a curative or a review? Can a larger bench look into it and correct the error? Because that was, I think, one of the prayers of the petitioners also. You were
Absolutely. I think if you see the jurisprudence development in the Supreme Court, it is that at times a view taken by a bench, another bench says that, look, it needs reconsideration, needs a second look.
right.
In the second look, it may be agreed with the earlier interpretation or
Right.
not. So if there's a 3 judges bench judgment, then other 3 judges may say, look, on these aspects we think a second look is required. It's nothing unusual, I would say. PMLA case, a bench sat there to listen to whether we need a second look on it.
Right.
Unfortunately, the hearing could not be concluded. Why it happened is known. And I was demitting office.
Right.
So I'm sure some stage a bench will be constituted by the Chief Justice of a 3 judges bench, which will have a look whether they need a second look or not on it.
But so since you did look at the case, since you were hearing it for a couple of days, from a legal point of view, do you think the PMLA verdict is something that you as a judge would have, upheld if it would have come to you as an additional scrutiny layer, as you just put it?
But I thought that it needs to be heard. There were some concerns in it, and those needed to be addressed. That's why we began hearing on it. I had put it to a 3 judges bench because I thought the matter possibly needs a second look. It didn't conclude. That's a different matter. Even if it had concluded, we would, if we had agreed to have a second look, it would have gone to a 5 judges bench. That's all that would have happened.
Right.
That's now for some other 3 judges bench to think whether they would like to have a relook on this issue. Let's take an example of the Arbitration Act on the stamping of the Act.
The recent judgment.
Recent judgment. It was a judgment which was delivered only in the month of May, I think, where 5 judges took a particular view, 3:2, and it was perceived to be creating some problems. And though through a curative method, ultimately it was the Chief Justice constituted a 7 judges bench to have a relook at it.
Right.
And the relook favored broadly the opinion of what 2 judges had taken. So this is a recent example of how jurisprudence evolves and develops by relocated. There are older constitution bench judgments which sometimes find favor, sometimes it is said no, time period, other factors, experiences lead us to have a relook. So let's understand what is a judgment. A judgment is an opinion. Let's not be touchy about it. It is my opinion today. It may be right. Others may favor it. Others may not favor it. Tomorrow, if I am in minority, that may find favor.
Right.
If I am in majority today, somebody else may think otherwise tomorrow. So I don't think judges should be touchy about issues of what is said, as long as we keep this perspective in mind that what we are writing is only an opinion.
Sir, circumventing orders of the Supreme Court by bringing in ordinances, stalling the appointment of judges, impinging upon certain institutions like CBI, ED. These are some of the criticisms that the government of India has faced in the recent times, as in how it has attempted to undermine constitutional principles. My question to you, sir, is should the Supreme Court be sterner to take notice of such actions and inactions of a majoritarian government in this regard?
So it's a very wide question. Let me start saying the Constitution envisages democracy.
Right.
Democracy is rule of the people,
Right.
reflected through whom they give a mandate to rule.
Right.
I'm conscious of the fact that we have a first past the poll system. Very few times would a government have more than 50% mandate. So that's one aspect of it. But then this is the method we chose. Democracy itself has many other methods. It can be a proportional representation or many such other options. But this is the constitution scheme. In that scheme, the court was envisaged as a check and balance. Check and balance and interpretation of law. Now, if the people give a mandate to a government, and there have been cases where there have been coalition governments, there have been cases where there have been majority governments. Mrs. Gandhi led two very large majority governments. Mr. Rajiv Gandhi led majority government. Present government is a extremely large mandate which is there. Then that mandate cannot be checked or reduced by saying, look, the opposition wants something which is not right. They have a right to disagree. They have a right to debate it out. But that the court should intervene and do that. So it's not the court's job, as I began by saying, to support or oppose the government.
Right.
It cannot be a replacement for the opposition. Now, you have talked about institutions like the CBI, ED, etc. There is a perception that is it that they are helping the government? Well, let's understand there are investigative agencies supposed to act. It's supposed to act independently, but ultimately a part of the government setup, government structure. So to say the government will have no role, it will never occur. It's never occurred, it will never occur. Similarly, the court's responsibility is a little more, I believe, yes, when there's a large majority government, because to keep the check and balance. But beyond that, I've said it can't play the role of an opposition. When I said can't play the role of the opposition, and I've explained what I meant was that there are certain aspects which are in domain of the political space.
Right.
And that has to be debated out. Yet, as I said, the responsibility is certainly a little more on it. See, we are also faced with a scenario where law is created to fill in a vacuum.
Right.
And then the government brings in the law. The lawmaking power is with the government, unless it is unconstitutional. So, at times, public or the opposition looks to court as a method by which it must say that I believe this is the right thing to do, so the government must do it.
Right.
That's not how it will work. Government has the mandate. So where the mandate is more, the pushback is more. Okay. Historically, this happened. Maybe in coalition governments, there's a greater political balance. So the pushback also doesn't occur to the judiciary. But the judiciary must also learn to not to be pushed back, but be in the space when it is provided for.
Right.
It of course becomes more challenging when there is a large majority government.
Sir, you were perhaps one of the very few judges in the Supreme Court who actually held a mirror to the government in the judge's appointment case. The hearing also proceeded to the length that you even warned of contempt if certain orders were not followed. Do you think you could do justice to the case?
See, the appointment process in our country went in a particular manner from 1950 to 1990. Then the judiciary in his wisdom, and I believe rightly so in the context of that time, came up with the collegium system.
Right.
It worked well for many years. The political class was not happy with it because they wanted a great say. And I'll say that people who are now in the opposition or who were in ruling or the reverse way around, as a whole, the parliament and the political class was not happy with what they believed was judges appointing judges. They wanted a say in it. In that say, the NJIC was passed, almost unanimously passed. Then it came to under challenge. Now, one of the intrinsic things in that, in the case for challenge was that it's a 6-member committee where a deadlock or a blockage could be created. The court took upon itself to determine that and quashed it. Now, there were many options, I think, available that time. I've talked about this, that one option was to let it work for some time, give it a chance, and see what changes are required.
Right.
The other was to, at that itself, make some changes. One of the, in hindsight, I've said is that if the law had been tweaked to give primacy to the Chief Justice, the 3:3 deadlock would not have occurred. So even if 3 judges are unanimously of the view and the Chief Justice has primacy in it, then it could have got through. What is important is that there would have been a space for discussion with the executive, which space doesn't exist in its sense today, except through process of a files coming over.
Right.
And that is delaying the process. That is my concern. My concern is that post NJAC, the collegium has faced many more challenges. The system has faced many more challenges because the political setup has not been really willing to accept that they have no say in it. And they keep repeating it openly that we also, I mean, we are the government, we have a say in it. That has created this ping pong battle which has gone on. But simultaneously, my view is, till it is the law, it must be followed. Till the collegium system is a law, in its letter and spirit, it must be followed. You don't like it, make another effort to bring a law which is more in conformity with what is expected of it or what the judiciary expects of it.
Okay.
And build a consensus around it. You know now why it was quashed, the judgment is available. But you can't say that I don't like the law, so I will not follow it. So the law the government will like will be followed, the law exists which the government doesn't want to follow, will not follow. That's the test where my difference of view has arisen. I felt that today, especially in metropolitan towns, to get somebody to accept judgeship who is doing very well is a challenge itself. I faced this challenge myself in trying to persuade young lawyers to accept position on the bench, because I believe it's the judiciary's job to endeavor to persuade them. Now, apart from a monetary angle, what has consistently been told to me, and they are troubled by it, is that if we put our neck on the block, what is the assurance it will get through in a time-bound schedule? They don't want their life to be in uncertainty when they are doing well in this. And the result is some of them withdraw it, some don't withdraw it, and are reluctant to give it a chance as a career option.
Right.
Now, that is something which is, as I said, has troubled me in this behalf. I believe that once the names go, there is a process to be followed. If the government has a reservation, you send it back. But what is happening is the names don't come back, or they languish in limbo. So today also 13 names are lying where they're neither back or forth. We don't know the fate. 4 names which are reiterated, that's still I demitted office. And they are not appointed. So there's a logjam regarding the 4. The 13, why the government is not appointing, we don't know.
Right.
Because no opinion, at least I don't know when the opinions have not come back. There are 3 Chief Justices recommended quite some time back. They have not been appointed. I don't know, I'm told that maybe the process is also not begun of consultation with states. So 3 courts are without Chief Justice. Another 5 Chief Justice posts have become vacant, for which no collegium was held. So we have not been able to take a call on them, and I'm sure the next collegium will take a call on them. So this creates an uncertainty where we are wanting to appoint judges. If there are 8 courts with acting Chief Justices, no recommendation will go from there unless specifically asked. So the process of appointment also takes its toll when the acting Chief Justice continues.
Right.
Also, some of them may not have very long tenures as Chief Justice. Some of the ones we have recommended don't have that long a tenure. Now, you take away a very substantive part of their tenure in this, their being active chief in one court or being a J1 in another court. I feel this is injustice to the judicial system, and the government must seriously look into it. In the proceedings, yes, it came before me because the court in a 3 judges bench of which I was a party with Justice Bobde and Justice Suryakant had laid down norms of timelines.
Right.
Application was filed that was not being followed. Insistence was to issue notice of contempt. We perceived that the better thing is to get the government to call, and some appointments went through, some didn't. For transfers, for example, another 6 transfers are still pending. Why? That's the court's call. So the attorney was coming and some attempt was being made to work it out. I don't think contempt was really effectively the remedy. What are you going to do? You are going to issue a mandamus for appointment. Ultimately, the president has to sign a warrant. These are constitutional issues. The president is advised by the government. So you have to make the government conscious of the importance of the issue and make them take decisions on these aspects while taking in view the consideration, the government's view. We do take into consideration the government's view. It's not there. At least in paper it is reflected, because on the file it comes, and we go through a whole rigmarole of the High Court recommending, coming through the government to the Supreme Court. So that view is reflected. It's not that the government's view is not reflected, and we take a call on that. Averagely, if you say more than, I think more than 50% of the names which are recommended from High Courts actually fall by the wayside by the time the Supreme Court clears it. If you look at names cleared and names sent,
Okay.
it's earlier I've seen it not even been 50%. So a lot of segregation takes place before that. Therefore, at least one which get through should be appointed.
Right.
That is my concern.
So you had expressed surprise in the open court when this particular case was taken off your roster. Would you like to say something more about that episode? Why was this surprise?
No, I had given a date. It did not come up on that date. It was mentioned before me. And I would have had possibly one hearing of that matter. Ultimately, my tenure would not make me get a second hearing.
Right.
Or there would be one effective hearing. And then somebody else would take the responsibility. So it did not appear on the date, but then the Chief Justice is the master of the roster, where a matter goes when it comes up. So I expected a surprise and left it at that.
So questions have been raised in the recent past regarding the listing procedure in the Supreme Court and also the master of roster powers of the Chief Justice of India. To set the record straight, sir, does a matter follow the senior judge on the bench or the judge the case has been assigned to?
So in different kinds of ways, there are a lot of norms of the Supreme Court. If you ask me, I really have not fully appreciated how it works, but I'm sure the Chief Justice and the registry knows how it works. Now, it does follow one of the judges normally in the process. I believe that matter followed me or came before me because with Justice Bobde demitting office, I was the next senior most judge. And it also, if you grant leave, then there is another methodology to be followed as an admission matter. So they have their own processes, how matters are listed. Principle of the master of the roster of a Chief Justice is well accepted. And it's difficult to work it otherwise. I have seen in High Courts, you will have to trust your Chief Justice to do the job. Even sometimes he may do, may not do, I'm not concerned, but the system requires the Chief Justice to be trusted with this job of master of the roster and a listing process. Now, what happens is the Supreme Court is the final court.
Right.
And therefore, the stakes are higher. And we are all human beings, so judges will have different perspectives at times. The bar gets concerned because a particular section of the bar would want matters to go before a particular judge on their perception of how he or she would handle that nature of litigation. And when that's disturbed, they feel a little agitated. But there is a system, and I think we have to trust the Chief Justice to operate it.
Right. So do you think, what is your case, what is your take on cases being shifted out of the roster of a particular judge without the judge being intimated in advance about it? Do you think that practice should be followed, especially when we are dealing with a constitutional office?
So there is, it will be very difficult, I think, to keep telling the judge that this matter is not going to your court or going to some other court.
Okay.
I do believe it should not happen that way. there is process, there are procedure, then that procedure must be followed.
Right.
Because consistently the Chief Justice's office and the Supreme Court registry have said that there is a process in place. So
Right.
that process has to be followed.
Right.
I don't know how much of a leeway is in that process
Okay.
to do so. I have not been privy to it really, so I can't say how it would follow. But that is supposed to follow, and so it will normally case will not be taken from a judge and posted somewhere else. I would say this. Dehorse the process.
Okay.
That would be a rare example where the Chief Justice would exercise the power. So let's not give too much of importance to this issue. Everybody is a judge of the Supreme Court. Everybody has to do justice according to what his norms are. Some difference in perceptions would arise. And the larger context when it gets more agitational in Supreme Court is on account of the stakes involved.
Right. Sir, just going back to the collegium for a brief bit, you have recently expressed your view that some of the judges did not quite turn out how you would have wanted them to be when you recommended them as a part of the collegium. If you could just throw some light on this, why did it happen? Like how did you look at this aspect when you actually saw the judges not performing as the way the collegium thought they would perform?
So there have been cases where a very successful lawyer picked up from the bar did not turn out as expected. See, we can't sit in the heart of a person.
Right.
And determine what would be done.
Right.
You look at established parameters. You will look at the possibility of performance. Take a call on consultation of. I would talk to some respectable members of the bar bench and then come to a conclusion that this person should be able to do a good job of a judge.
Right.
It has worked in many cases. It did not work in some cases. In Chennai, the challenge is also that the method of appointment envisages cross-sectional representation
Right.
of different communities and representation apart from the gender issue, which is always addressed. It's more minute in character than other places. So the endeavor is to pick up the best from that sect or subsect,
Right.
whom you are looking to. It should not be that you're looking to look lower down than there's a problem. At times, as has happened, there have been. Chennai has faced the most extreme case of a problem which my predecessors and I dealt with for a judge. But it has also happened that I have thought the judge is fairly good, represents this community, and comes in as a permanent judge, and sometimes day one problems have started. I was not sitting in the heart, then you try to manage what is there. You know, the appointment process envisages somebody coming as straight away a permanent judge if a permanent judge vacancy exists. It's a thought that, you know, in the bargain what happens is when vacancies don't get filled, the permanent vacancies exist. Because permanent vacancies exist, so people come in as permanent judges straight away.
Okay.
So the senior judges don't have a chance even to gauge how the person turns out as a judge. That's the negative aspect of it, of straight away coming in a permanent vacancy. So some of them have been more outstanding than I thought would be. There have been those cases also. Some of them did not rise to the occasion. And it has happened. Historically, if I look back before my time also, there have been sometimes very excellent judges, excellent lawyers, who when appointed as a judge became more technical, slowed down, were more suspicious. So there have been many factors. Integrity is not the only factor. So it's not always necessary that a very successful lawyer will be a very good judge. But normally somebody from whose hand work has gone, I think should turn out to be a good judge.
Okay. So recently, the former judge of the Supreme Court, Justice Rohinton Fallinariman, critiqued the Article 370 judgment, saying that it condoned an unconstitutional act. What is your response to this?
See, I saw the interview of Falli, I saw the interview of Rohinton. Rohinton is somebody I've sat with. Both of them I immensely respect. But then, as I said, law is a matter of perspective.
Right.
I, despite reading everything, I have not come to the conclusion that in my mind what I did was something which needs a relook. I believe what I did was correct. It is my thought and belief that the manner of assimilation of Kashmir in India carried a slightly different path. I've said so even on one point differing in whether part of sovereignty survived or not. But ultimately, assimilation over a period of time was the objective. That is why the placement of the provision in that part of the Constitution. And it continued like that over a period of time.
Right.
By different geos issued, powers were confined to the center. Now, something remained. Should it have been changed? Should it not have been changed? Should the provision have been obliterated or not? It was a political call. It's a political decision. Then we are testing it constitutionally only. We are not concerned. And I thought that was, that is the nature of the provision. And 5 of us opined so. Other is the method, the procedure. There have been criticism of the procedure, largely, including by Fali. Well, they are entitled to their view. But we thought that given the scenario where the state was in existence with no government, state government in power, and many other issues and the center in power, it was a method which was available. Now, that method being available, they exercised this.
But so one question that comes to my mind is the aspect of turning back the clock. We all know the delay that occurred with the 370 hearing. It could have perhaps happened earlier. My question to you is, sir, an act which was done in 2019 was not just an act. What followed were n number of changes in the valley, whether it be reorganization, whether it be administrative changes, whether it be tenders, orders, etc. Do you think even if Supreme Court would have seen something unconstitutional in the act, could the clock, could it be turned back if you would have not agreed with the abrogation?
So you are right to an extent that passage of time does create a difficulty in turning the clock back. But if really the Supreme Court was of the view that this is something completely unconstitutional, then I see no way where Supreme Court would say no. Well, passage of time takes care of this, though we feel it's unconstitutional. At best, it would have given some time frame for it. But it's not impossible, but there are challenges with the period of time. The period of time also elapsed because the hearing was going on at one stage, the matter was being heard, and then some sections of the petitioners, lawyers, took a turn where they fundamentally challenged the issue of whether this bench of 5 judges could at all hear the matter.
Right.
By that time, some had concluded their arguments actually, in toto so far as their challenge to the provisions were concerned.
Right.
So there was a digression of the opinion. And ultimately, we had to reserve order because if we couldn't hear it as 5 judges bench, then there was no point in our hearing it further.
Right.
That took some time, the pronouncement by the then head of the bench. And thereafter, in a way, it, for the time being, derailed the matter, in a sense. Thereafter, as mentioned, I can't really say. It's again a prerogative every time the Chief Justice to place when and how the matter has to be heard. And finally, it got a hearing after some time. Undoubtedly, there have been some lapse of time.
Sir, you hail from the valley, and you have witnessed the communal strife which took place in the valley, which led to the exodus as well. Do you think that factor had any kind of bearing in your judgment of the case?
So it had a factor in the postscript I wrote. So far as the legal principle is concerned, I've been 22 years a judge. You may have your views one way or the other. You learn to keep your personal preferences apart and rule.
Right.
All human beings, can it be said the judge is apolitical in the sense he doesn't have a political belief? Every judge would have a political belief. But you are trained to keep that political belief out of your adjudicatory process as a judge. That was one part of the task. The latter part of the task was something which I saw the pain on every side in that place. Yes, the Kashmiri Pandit community was compelled to move out. 4.5 lakh people were displaced. I don't believe they received justice at the hands of whichever government there was. In terms of attending to the problem, the situation became so drastic, army had to be called down to protect your boundaries. The very existential status of the state came into question. When the army comes in, which is supposed to fight wars, not control law and order, it fights war in its own way. It was a warlike situation.
Absolutely.
The war was fought. And there were then That's why I've referred to state and non-state excesses which have occurred both. So there were another section of people who remained there from a different community who suffered in the bargain also. So we have seen a whole generation grow in this turmoil. Um, Somebody who is 5 years old, 6 years old is 40 years old today. Whole generation is gone.
Absolutely.
Most of them have not seen the conditions in which people live together. Um, it was one of the most comparatively assimilated society. Um, it was far safer than any other place. Uh, I used to go out for walks in Srinagar right till 1980s. I had my own orchards there. I've gone out late in the evening with ladies. I would not do it in Delhi, but you could do so. And this occurred right till 1989. It would go on. There were rumblings, of course. There were problems and rumblings before 89, which were continuing. So that's why I've referred to the period of 80s. Some are political issues which I would not like to comment on, but the rumblings had started. And then resulted in 89-90 episode. So do we move forward from here, or we carry our own grievances of both sides? 1947 saw India's partition. People suffered, really suffered. Loss of life, loss of property. And on a personal note, my family also went through this.
Absolutely.
So this was a second hit in that sense. But ultimately, after about a generation, people adjusted to their new surroundings, adjusted to the environment. Seeing these two events, I felt something must be done where there's acknowledgement of the wrong which has happened. Not with the idea of now trying to prosecute, but at least acknowledge that this has happened. It's not that a film comes and somebody says, oh, this doesn't reflect the truth. That should not happen. So accept what has happened and let's move forward. Because otherwise we'll be bound by histories, and that's never good. So if we want truly peace to remain and be restored and work together, then we have to move forward by accepting what has gone wrong and when it went wrong and who are the people who suffered in it.
You also had said, sir, that your house was burned down during that period.
2 of my cottages were burned out.
So do you vividly remember that?
One happened at the beginning of the problem. One happened much later when I'd gone there. I would not like to say why it happened. There were different reasons, I think, for it. My house barely survived. It was vandalized, but my family house, which is it's a 120 years old house, survived it in terms of its 4 corners and structure, which is what I've tried to redo up and now look to some stay there. I stayed this summer after 1989, and in 2023 I stayed in the house after that.
After that you stayed?
After that. So this period of time was always, I was living in government accommodation courtesy the office I hold, but I used to always feel that in what was really a home to me also apart from Delhi, that I'm not able to stay there. So,
do you think the abrogation helped you go back to the valley again?
No, I had started going back earlier. I was very much there earlier, going there, seeing what could be done. The processes I had begun were before that. What is certainly a redeeming factor when I stayed this year, I found, was that a lot of development has taken place.
Right.
Maybe for G20, in fact. But my house is next to facing a river area, and they built areas for people to walk, cycle, etc. I saw the local people walking late at night, tourists walking late at night. Far more bonhomie, at least. Maybe I think the society is trying to come out of the trauma it has been through.
Right.
And wants to look forward. That is my belief.
Sir, just one question that I've always wanted to ask you is regarding the same-sex marriage verdict. You and the Honorable Chief Justice of India were in minority on some of the issues. But, just taking it a little off the record, in the sense like off the judgment, did you and the judges who were in majority attempt to, reconcile each other's point? Was there any attempt to come at a unanimous verdict in this particular case?
At some stage, yes. But there was a divergence of view. It happens. See, it's a social issue.
Right.
It takes time for it to change. I was part of this path from 2001, when the bench of which I was part of, soon after becoming a judge, issued notice. It was, I can say, my keenness that this matter needs to be examined. The notice was issued. It went through a whole round, dismissal to Supreme Court, Supreme Court, back to High Court. So even the decriminalization took a number of years. And then finally the Supreme Court, then curative, then other things. So if you look at the history first of decriminalization, that also took time. And it got settled by the privacy judgment actually, because Justice Chandrachud's judgment and my judgment together constituted a judgment of 5 judges out of 9,
Right.
which had said that this is part of privacy.
Right.
So the latter judgment which decriminalized it was a sequitur to this when the major issue had been sorted out and settled. So this was a further step. This further step meant that we had to be talking about now recognition and people staying together. Now there were ramifications in terms of different religions, beliefs. Socially, there were sections of society which thought we were not ready for it as yet.
Absolutely.
There were others who were saying no, this is non-appreciation of the point. And ultimately, the court was looking in the point of whether, keeping in mind the Special Marriage Act, it can be fitted in it. Now, some people felt no, it could not be. It doesn't have that nature of a right of marriage. Some of us felt that even if it was so, a civil union could be a way out to give. It happens sometimes that maybe social time is not right at a particular stage of time. It's a call to the future. Like it happened, maybe few years down the line, some other view is taken.
So that is what I wanted to ask you. Do you think after a decade or so, the minority will become the majority judgment?
I believe society is changing. I look at it from my perceptions, my generation's perspective, and my next generation's perspective. There's a huge difference. So when they become the decision makers, I'm sure the situation will change. I'm positive that, keeping in mind the history of all that has gone by, even maybe at times the law may take its own course after all. So it may be possible for the government to enact a law. After all, it has enacted laws for some people, some sections having different nature of a problem.
Right.
And they may think of giving some rights to, in what manner this, you call it marriage, call it by any other right, but more important is rights of adoption, the rights to live together, rights of inheritance. Many things come into picture. It's not so simplistic.
Absolutely.
And maybe a composite act which the government feels would take care of this section of our society would something, I will not remove it from the realms of possibility in years to come, which may itself address the problem.
So, pendency is a multifaceted issue. According to you, what are the key 5 factors that needs to be brought in urgently to curb the pendency rates? And I'm not just talking about the Supreme Court. I'm talking about the judiciary as a whole.
So the biggest challenge is the volumes. Now, we want every case to go from cradle to grave, going through number of tiers of scrutiny. If this is the position, then there is no solution, according to me. Therefore, some out-of-the-box thinking is necessary. One of them is, let's look to models where people have found solutions. US was an example of this, facing in 1980s. They found a solution by giving prominence to alternative dispute resolution mechanisms.
Right.
They took up plea bargaining, arbitration, and mediation has worked hugely. I am personal witness to it, having gone to the US to see their system under a justice exchange program. I was there for twice 2 weeks. It is very structured. The mediation process is very structured.
Okay.
And people's thinking is also in this way that they need to sort out. Otherwise, the cost of litigation itself becomes very prohibitive. So they, less than 3% cases go to trial. In our system, 99.9% cases go to trial. So how will it work? Plus our population, plus our judge population ratio. So all these become challenges. And also that the government is a litigant in more than 50% cases. Government, public bodies, public authorities. See, let's pick up the All England report. How many cases do you find where a city borough or some city authority is in litigation with a citizen? Every high court here, you have more than one judge dealing with jurisdiction. Say in Delhi would be Municipal Corporation of Delhi, Delhi Development Authority, vast areas of litigation. Citizen and their municipal authorities into so much of litigation. So there are some natures of litigation which need to be resolved. That's most important. Mediation, I think, I'm a great votary of it. I've multiple times trained myself as a mediator, going through the processes of training, both of advanced training and training, when it began, from then on. I also feel that mediation offers a better result than a litigation.
Right.
Leave aside criminal matters or constitutional matters, criminal matters also serious criminal matters. You can resolve many issues to your liking. Law may provide for something to be given in a particular manner,
Right.
but it may be that both of them don't want that solution to come.
Right.
So then they are looking, they don't understand the niceties. I've got something which I don't need. So mediation training begins by saying that when a law divides an orange among two people, it divides it half and half. But the needs are different. Suppose one of them wants to make a marmalade, another wants the juice to make something else. Then one can get the rind and one can get the juice. I think that reflects the view why mediation is a better solution. And we have a long history, not of the modern mediation, but in a different form of mediation. After all, Mahabharata occurred because it's an example of a failed mediation. That's
Absolutely.
all. Krishna Bhagwan went to give mediation options, reducing the demand of one side to a very limited amount. But Duryodhana did not agree to it. And you saw what the result is. Of course, mediation therefore requires a consent,
Right.
as then was required. So if you have to move forward, somebody has to give and take a little
Right.
and come up. So this is, I think, the most important aspect. Secondly, as I said, number of tiers of scrutiny which every case must go
Needs to
through.
be reduced.
The government must litigate less. It must say so if there are people not wanting to take the responsibility, whether the decision should be accepted or not, create a mechanism where it should be accepted. Smaller cases must be resolved in a different manner. So I judicially suggested that the government should look at a case. We are celebrating 75 years plus of our independence. So let's look at even at one-time solutions. If the criminal jurisprudence is creating a backlog in a large amount of cases, let's look at cases of up to 7 years or 10 years sentence, single incident. And often you will find these people who are in prison and have served under trials are socially, economically weaker section.
Absolutely.
And the environment is such where sometimes offences crop up. They may crop up over land, some water, they are not major issues in that sense. So if some kind of a part sentence has been served as under trial, a bond is taken, it will heal the processes. It will give the courts time to concentrate on more heinous cases. Mere changes of law, I believe, is not the solution. The thought process has to change, and we must encourage. Similarly, plea bargaining. Now, we do really a sentence bargaining. US plea bargaining operates in a larger field. So these are examples to be taken how to reduce the litigation. If we feel that this amount of litigation must prevail and we must carry it through the last stage, I don't think it will happen. Even if we increase the strength of judges, that of course is required.
Right.
I'm not getting away from that issue because judges are overburdened. That creates a culture of adjournments because the judge knows if he has 100 cases, even if he adjourns 20, he can't finish the remaining 80.
Absolutely.
So that's the challenge in which some people take advantage of it. Another aspect which I feel very, very strongly is the court management systems must improve. Every judge must be trained in court management. He is the court manager of his court and the institution is also to be court managed.
Right.
So cases should come up in a manner where they can be handled. If you have 150 cases, you can't handle them. What's the point of listing them? When they get adjourned again, or if you give shorter dates of adjournment, then it doesn't subserve the purpose and the litigant is coming again and again, expenses are going up again and again. Of course, some of them have expressed a view that suppose we give a date of 6-8 months, then that fellow will be troubled, so let us accommodate. That also doesn't help. Also, I can say, advise my brother judges, younger judges, that when you start a case, finish it. Don't send it 3 months hence, because you want to accommodate other cases who also want to be heard. At least something should get over. I also believe that it's time that the legal fraternity learns to argue in a compact manner.
You had even mandated the 3-page.
Yeah, so I used to say, initially I said 3 pages with permission more. People handed me 6 pages. I took out the last 3 pages, handed it back to them. I said, I look at 3 pages. Learn to put it down in readable fonts.
Font size?
I told them readable fonts, 3 pages. You want 4 pages? Tell me in advance you want 4 pages or 5 pages. So the argument system has to be more disciplined. In US, I'm told that if half an hour the cases are decided, you are given half an hour to argue. If you don't if half an hour expires and you have not completed a sentence, you claim liberty to complete the sentence. That's what one of my colleagues who practices there said. From here it goes on day on. We are also burdened with a lot of precedents, and we expect every precedent to be examined and considered. So the lawyer also will ask his junior to get a compilation. Everything is reported. So the compilation which accumulates, everybody will dump a compilation on you. And I keep telling them, look, a judgment is required where I don't agree with the proposition with you. Maybe one. If I don't agree, show me a judgment which lays down the principle of law and is apposite on facts. There can be one or two. Don't try to create every case law and hand it over to us. So I discourage. I used to throw back the compilations and say I will not take compilations like this. Because when you pen down and sit down, you have some 50 cases unnecessarily in a simple matter. And then the expectation is each case must be dealt with.
Absolutely.
You see the American system, they put it at the end only, that these cases are cited, that's all. Even from the England where we borrowed, you don't see this kind of arguments go on. And we as judges have to also possibly learn to discipline ourselves. Our judgments should be briefer, should be to the point. We are not theoreticians, I believe. That's the job of academicians, to do, write, criticize. We are doing a task. The task is to settle a dispute. That's the focus. If we are settling a dispute, there is no need to show the knowledge which we may have, but settle that issue. So more brief judgments, I think, are important. In my lectures to the Judicial Academy, I used to go and say, look, when I was a student in the school, the English grammar book used to be Wren and Martin. I said, the red book. I said, it is a very nice chapter on pressy writing. Everybody must learn pressy writing. Don't repeat what has been said. So these are the multiple changes, I think, which can help. And government being more careful in enacting law. Legislative drafting is a skill. We may criticize the British laws, but some of them are well drawn out laws which existed in the manner they were drawn up. So when you replace, the new laws must be as well drafted. It may cater to the current scenario. Sometimes we've just incorporated part of the law, that's fine. I believe Evidence Act is one of the very precisely drawn up acts as it existed, and maybe a lot of it is redrawn in it. So the unnecessary litigation is not bred out of statutes, and there should be a government study of a legal impact study, which I call. When you enact a law, what is the ramification will it be? Have you strengthened the infrastructure? Have you created more judges? Two gross examples of this is 138 Negotiable Instrument Act.
Absolutely.
And the prohibition law in Bihar, where at some stage only bails were being heard. When bails were not being listed, it was mentioned to us. I talked to the then Chief Justice, and he said, look, 16 of my judges are doing only bails out of 23. Who will do the remaining matters? So these are challenges because it was fine-tuned ultimately, some things were given. So when you create a law without a prior discussion and history and seeing the legislative impact of it, this is a problem which crops up.
This kind of brings me to my question, where I would want to ask you that, we are currently at the cusp of what I would call as a legally kind of a very revolutionary phase in the Indian history now, when three most important criminal laws in the country have been done away with, and a newer, updated, modern versions have come to take place. My first question is, do you think the overhaul was needed? Do you think a minor amendments would have done, or a complete new look, avatar of the laws had to be brought in, since you have dealt with these laws very deeply throughout your career?
So I must confess I have not gone through these laws. They were circulated by government, but I didn't think that was the time, not knowing what the future would be, to go through these laws. There were changes obviously required. It could have been done possibly by making the changes, but the political wisdom weighed in favor of bringing a new law into force. But I hope, and what I've heard is that a lot of the earlier law has also been ipso facto incorporated in this, including the Evidence Act. My only concern is that what would be the legal challenges which would arise, and how much further litigation would it generate by this changeover, and whether the government has done a study of the possibilities of problems which will arise. So apart from creating a law, the questions which would arise out of legislation are important, and they may require sometimes settlement before the law is fully applied. So those would be aspects, I think, which should concern us. I feel there will be a litigation generated. Because out of nothing we generate litigation. Here there is something out of which litigation will certainly get generated. And we will have to tackle it, I think.
Would there be confusion? Do you think there will be a lot of confusion?
There will be a hiatus period where things will take a little time to settle down. You can't suddenly change laws established over a long period of time and then expect that settlement will immediately occur. It will not occur. So on the lighter side, somebody said, look, 400 BC तो हमारे यहाँ as a phraseology है, or even in a film is made on 420 now. To look into the provision by some other number will take time.
Even 302 for that matter of fact.
You say 302, 304. So what we say zaban pe chadha hua hai. So it will take a little time.
302 is something that.
Yes.
Sir, recently, we are the last leg of the interview. Recently, a former top court judge has opined that collegium is the least of all evils. Do you think, is there an alternative to this?
Collegium system worked well, as I said earlier. It's when you say least of the evil, it's not an evil, it's a system which must operate, to my mind. And it did operate, but there are problems because the political dispensation thinks otherwise.
Right.
So now, do we have a scenario where political dispensation thinks completely otherwise and we persist with the collegium? That is what is breeding a friction, in my view. So, but then it can only change if the government is able to build a consensus for another law. Of course, it can be tested always, it will be tested because there will be always two opinions on it, but which takes care of the concerns while striking down the earlier law. If those concerns are taken, I think there's definitely a better possibility. Even then, most people didn't say this is completely wrong, it should be thrown out. They said that some concerns which were expressed and which were to be taken care of while enacting the law were not taken care of, which resulted in the situation. And one of the main issues was the predominance of the judiciary. So when you created a 6-member committee, if it was a 5-member committee, maybe it would have passed muster. Therefore, I said in a 6-member committee, give Chief Justice a casting role,
right,
or something else. So I do believe that the judiciary has, in an Indian context especially, has a very important role to play in appointment of judges. But it may not be the sole role to play in the appointment of judges. So the government will want its space, the political people will want its space, and this is irrespective of who is in power. It's a conceptual tug of war which occurs. And if that is taken care of, I think the problem can be solved.
So, ever since the court proceedings became virtual, did you become more conscious of what you were speaking in the court than you were earlier when the court proceedings were not virtual?
So before they were virtual, I did have some apprehensions that it should not become another place to just show for the lawyers to play around more or play to the galleries. We've seen in Parliament sometimes this issue arises. So that was my concern. But I think broadly it has worked out smoothly. I don't feel that lawyers are more exhibitive in character than if they would be. This is not so. We've also learned to, initially we were a little more reserved because we felt everything we said was being recorded, I would say. But slowly it eased into its own self. As it is in the Supreme Court, because every word is caught on, you are definitely more careful than as a judge of the High Court. As the Chief Justice of the High Court, you are, especially in PIL, very careful because you don't know what said may be construed in another manner.
Right.
People don't understand that a lot of questions which we pose are only to elicit answers. It is not an expression of view. Right. It is to elicit answer or something which troubles your mind. So I've said in another interview that if you are a very quiet judge, the bar always had a problem. I would have a problem because I would not know which side the judge is going. So it's better to have a judge, not an over-talkative judge, but a judge who at least asks the questions for the bar to respond to the questions. And over a period of time, it has fitted in well. There was the public curiosity who wanted to see. So when constitution benches were available to the public, a lot of people saw it. It satisfied a curiosity how the court works.
Right.
And slowly people concerned will watch it. So when a new thing comes, it takes a little time for it to be accepted. But I believe today that the virtual system is here to stay as a parallel system. It should be made available in all courts simultaneously, so that the lawyer can take a choice whether he wants to do it, appear physically or not. And I think it has an element, if I may say so, of women empowerment also. Because women often go through a greater needs at home. The issue is also of children. And they are able to attend to the courts through the virtual mode. I've seen it in-house into this factor. And there is also um, the some of the matters I found in especially SLP stage, where cost is an issue. The local lawyers say from Chennai appearing. Okay. If a notice is issued, they'll think it worth the while to engage a local counsel. They're appearing from there and doing so. So those people get some opportunity to appear.
Right.
On the other hand, the litigant doesn't have to enlarge his costs by coming here because you are working against an 80% plus dismissal rate at that stage of time. So I think there should not be somewhere some courts have hesitation. Why should we do it? We also come to court. That's not how I believe a judge should look at it. Your problem and a lawyer's problem is very different. Look at it from a lawyer's point of view. Look at it Delhi, where there are many tribunals spread all over Delhi. Anybody who travels to different places, how does he meet it? How does he know that item 1 will go on for 10 minutes or item 1 will go on for half an hour? So it helps having a hybrid system. For example, I have always given a first passover, whether a lawyer comes or not. I, as a lawyer, face this problem. I did volume works and I faced this problem. I persuaded sometimes other judges to agree to this principle that a lawyer can be stuck. He may not think he'll get stuck, but he's stuck in item 1. Yours is item 2 or 3. What does he do? He'll seek a passover if required. So this much adjustment, I think, for the bar's convenience should be there. You must realize their problem also and do so. And the hybrid system, I think, is an ideal system.
So my last question to you, how do you look at post-retirement jobs for judges?
Very
Are you
individual.
going to take up any?
Second answer first, no.
Okay.
First answer is very individualistic. There are tribunals in existence. They need to be manned by people. There are people who man those tribunals and assist in them. It's not my cup of tea. I've spent too many years in judgeship now to look at anything else and one time to myself. Apart from my own view that having been the second judge in Supreme Court, which carries with it its own onus and own responsibilities, I would not like to venture into this. There are questions posed on some political patronage appointment. That's for that judge to take a call. All I say is that a judge who's been to the Supreme Court, who's been a constitutional authority at that stage, give him this option to think what he believes is right or not right to accept an assignment. Again, it's not my cup of tea, that's fine.
Right. Thank you so much, sir, for giving us the time for this interview
Thank you.
series. We're highly grateful.
Thank you so much.
Subscribe to our YouTube channel and click the bell icon.